Okay, everybody, welcome to everybody who's here in person and everybody who's online. Thank you for being here. We have a great hour and a half for you on talking about who signs the contract. First, we're going to get started with our sponsor, Missy Hill. Missy, would you want to come up and talk to the nice people here in person and online? She's from Blue Sky Lending. She's going to let you know a little bit about her company. Welcome.
Thank you.
You're welcome.
Good afternoon. My name is Missy Hill. I'm a numerical wizard and a fulfiller of dreams, otherwise known as a mortgage loan originator. We are located in Lakewood Ranch, Florida, and we've been voted the #1 mortgage lender for 6 years in a row. We have, of course, all the basic products that everyone else would have, the conventional VA, USDA, and things like that. But we also have some pretty neat products available. We have a one-time close construction. What that means is we close at the beginning of construction, and the constructor has 11 months to build, and the person only has to qualify at the beginning of the loan, not at the end of the loan. They lock in their rate for that time. If the rate goes down, they have a chance to modify at the end. You get paid right away. You don't have to wait 11 months to get paid. So it's really nice. If you have any more questions, let me know. Send me an email. And we also have a DCSR, which is a debt credit service ratio loan. So if you have investors that want to start building their real estate portfolio, they're qualify on the rental analysis of that property. It's not your income, it's not your debt to income ratios, it's a rental analysis of that property. So it's pretty decent if you want to start building an investment portfolio. That is all I have to say. That's all. You guys have a great day. Take care.
I will just give a pitch for that company. I just have a closing coming up that would never have closed, I'm sure. They just, they're just amazing, every single person there. My name is Deborah Patel-Hauge. I'm a realtor with Michael Saunders. I've been a realtor, this is my 40th year, so I'm kind of like an old fixture around the office, but I'm also on I serve on the Realtor Attorney Joint Committee. This is who's putting this program on for you. And the three wonderful attorneys on the panel have kindly volunteered their time to answer some questions that every single realtor would want to know. I'd like to first introduce them to you. Sitting to my right is Peter Pike, and he has 39 years experience as an attorney. He's going to answer questions today on powers of attorney and homestead exemption.
Oh, hello. Thank you.
And sitting next to him is attorney Kara Scott, and she has 27 years experience as an attorney, and she's going to talk about trusts. And then to her right is Matthew Kelly. He is going to speak about probate. He has 8 years experience. He's also a lot younger than the rest of us. Okay, all right. So we're first going to ask a question, Peter, off your list. And the first one is to do with powers of attorney. The question is, how do I know if a power of attorney can be used by my customer for a closing? And does it make a difference if it's the buyer or the seller?
Okay. First of all, powers of attorney are wonderful things. Sometimes you may have customers from out of state bringing an out of state power of attorney. Sometimes they are in state using a power of attorney that they had prepared for them here. Sometimes they're very old, sometimes they're very new. And Florida has a relatively new power of attorney statute. It's about 10 years old now, but basically it changed everything, and it requires your power of attorney to be very specific. So the best answer to that question is, if you have a seller who wants to use a power of attorney to sign a listing agreement even, the best thing I would recommend is call an attorney. Everybody here should know someone, and out there you should too, know a real estate attorney who you can call and just say, can you just take a quick look and let me know if you think that this will work? As a general rule, out-of-state powers of attorney are good. However, an out-of-state power of attorney might not be good for executing a deed, especially for homestead. There are special rules on that. So the answer to the question is, how do you know? You don't. It's really a case-by-case thing. there's a lot of different things going on when there's a power of attorney.
Okay, thank you. Okay, Kara. Your first question is, where should an agent look for the correct seller name other than the property appraiser's website?
Okay, and first of all, thanks everybody for being here, appreciate it. First, you want to go to the property appraiser's website, that's always an excellent place to start. That will give you an idea of who might be the title owner of the property, but it's not always accurate. So you want to then go to see the most recent recorded deed, or what's also known as the vesting deed. And there is probably 9 times out of 10 or even more, you'll find a link to that deed down at the lower end of the property appraiser's website. Unless it's a very old deed, but if it's a more recent deed, you click on that link and it'll take you right to the deed. And from there, you just look and see who's the grantee on that deed. You can find out if it's a single person, a married couple, is it a corporation, is it a trust? So that's a better place to get that information.
Okay, I have a quick question for you as a realtor. What about Realist or IMAP? Are those accurate locations to look for the owner of a property? Because we always run to that as a realtor.
I have never used either of those. I just use the property appraiser's website and then I look at the deed.
All right, okay, thank you very much. Okay,
So can I ask a question on that then? Presumably the property appraiser uses the information on the deed to populate its own website.
Yes,
And you've got potential human error of missing name out, misspelling a name, misdoing whatever.
that's correct.
okay.
Always check the deed. What the little blurb they have there is not authoritative, because that's not gonna be the thing that determines.
And sometimes they use shorthand. They don't have enough space to fit it all in.
And one other thing, they don't update everything within seconds after something's been recorded. It can actually be months. So it may be okay, but you might not have accurate information.
Okay. Okay, Matthew, probate. Who is authorized to sign for an estate, and how do I know who the right person is?
So for an estate, it's gonna be the personal representative. Now, you can get a personal representative one of two ways. If there's a will, it's most likely gonna be the person who is nominated under the will. If there is no will, there's a statute in the Florida probate code that sets out the preferences. So it's the spouse, a person nominated by the heirs, there is no spouse. And if there's no person who they've nominated, then it's the heir nearest in degree to the deceased. But that's not what makes the PR. The court has to appoint the PR. So you may have somebody who's been nominated by a will, and you might see the will and say, okay, well, they're the PR. They might think they're the PR, but they have to be appointed by the court before they can take action for the estate. So what they're going to need is an order appointing them, and then more importantly, they're going to need what's called letters of administration. And those are recorded in the official records, and that's the document that gives them authority to act and to sign a deed or whatever it may be.
All right, thank you. Peter, can we use a power of attorney for someone who does not have mental capacity?
And by the way, that's a good question that I came up with. All right. I'm sure everybody knows, or at least I hope you know, a power of attorney dies when the principal dies. So if I give somebody a power of attorney and I die, that power of attorney is no good anymore. If it has certain language in it that says it will survive my incapacity, if I'm put into the memory care unit and I have no clue who I am, that power of attorney is still valid. So yes, it can survive, but it has to say so in the power that is expected to survive. And I'd just like to throw one thing in. I'm sorry, Matt, not to step on your toes, but when it comes to probate, there's one other thing, since I'm the homestead person also. If it is the person's homestead, then the personal representative actually has no rights in the property. It's the heir, it's the spouse, if you know, there has to be a spouse, or if there is an infant child, spouse and or infant children, it basically goes to them immediately upon the death, and it doesn't go through the estate. So it can get a little tricky that way too, when you're dealing with homestead.
Questions? No?
By the way, the idea behind all this is to make you realize this ain't easy.
Yeah.
Particularly with the area of the estate and then the homestead issue. That's an area where you see a lot of issues. Because people will either think, okay, my parent has died and I'm the lineal descendant, I'm an heir, so the house is mine. But even with that, you know, while it does automatically inure to them upon the death, that happens legally automatically. For title insurance purposes, they're gonna need an order determining that from the court. So they would need an order determining homestead status of real property.
Yeah.
So there's a lot of,
And probably for also contract enforcement purposes as well.
Yeah.
You probably need an order of the court as well to say they really are. It gets ugly.
And how long does it take from time of death until an order is, kind of granted?
you can get that, I mean, pretty quickly. If you petition, if you open a probate, once that's open, you can file a petition to determine homestead status of the property. And you can have that, probably within a few weeks. Now, there is the issue of the creditor's claim period, which comes up, and that's a whole nother kind of wrinkle to it. Because I think I've seen, I know you all do a lot of more closings, I do primarily litigation. But I've seen title insurers where some of them want you to wait the 90 days before you close on a property. Have you seen that?
Well, if it's non-homestead, absolutely. Yeah.
Right. Well, I mean, no, it's a homestead too.
Well, if it's homestead, but if it doesn't go to lineal descendants where you get the benefit of that homestead, then yeah, you gotta wait because there may be, I'm involved in a transaction right now where the homestead property went to 2 children and a friend. Because it went to the friend's share is not protected homestead. So we have to wait until, see what goes on with creditors' claims. Actually, we're okay because we're doing it through the personal representative. So all the money is getting paid into the estate. But otherwise, we would have to wait.
Yeah, so for the time frame, I mean, it can vary depending on the facts, but if you're talking about just getting that order, you can get that probably within a few weeks. I mean, if the probate's already been commenced, then
Kara, back to the trust. What if the owner of the property is a trust, and who is authorized to sign for the trust?
Well, again, you want to look at the vesting deed, and if you're lucky, it'll give you the name of the current trustee, and that person is still the trustee. It'll give you the name of the trust. It'll have trustee powers right in the deed that says that this person is authorized to conduct real estate transactions. So that's the best case scenario. However, if you might get a deed, and I've seen these prepared by out-of-state attorneys, who sometimes don't know, they won't include the trustee powers. Also, I've even seen deeds where they simply name the trust as a grantee and don't name the trustee. In that case, you need an attorney to review the trust document itself to determine who's the trustee. Is that trustee still alive? Has that trustee resigned? Is there a successor trustee? There's a lot more that needs to be determined at that point. So at that point, an attorney really needs to review that trust document.
Thank you. Matthew, Maps, sorry. Will the property appraiser's website show who the personal representative is? And what happens if there's no will?
So, like I said before, I mean, you can go to the property appraiser's website as a starting point. I wouldn't rely on that other than as a link to get to the deed, to find it. In the case of an estate, though, even that may not be up to date, because again, the thing that gives the personal representative authority to act is the letters of administration, not even the last deed, because the last deed is still going to show the deceased person. So the letters are recorded in the official records as well to get to, but you're going to want to, if you're trying to confirm these things, you're going to want to go to the source documents and make sure that you're looking at the right thing. Because you talked about a couple of other realists, I think, and these things are just drawing information from whatever they can find on the internet. So none of them are authoritative. It's not going to answer your question with any level of confidence other than, this is what they have found is the case, but it's not authoritative. And what was the second part?
What if there is no will?
Well, so if there's no will, then it's called intestate, and basically it's governed by the Florida probate code. So as I mentioned before, if you're talking about who the personal representative is going to be, it lists out preferences in that statute. Who it would be. First, the preference would be the spouse. If there's no spouse, then it would be a person who the majority of the heirs have sort of elected to be the person or nominated to be the person. And if there is no agreement on that, then it would be the heir nearest in degree. So, child before a grandchild, et cetera. If there's more than one of those people, then it's going to be up to the court. And so you'll see cases where, you have one person petitioning to administer the estate, and you have a counter petitioner also trying to administer the estate, 2 children or something. And then ultimately the court is going to make that selection, and it's going to enter the order appointing them and letters of administration that provide them the authority to act.
Okay, go ahead.
I'd like to add something else, regarding the property appraiser's website. Sometimes when somebody dies, their children or spouse or somebody sends in a death certificate or something to the property appraiser to let them know, hey, this person's no longer alive. And they seem to just change the names in there to the estate of whomever. That does not necessarily mean that a probate has been opened. That does not necessarily mean that we know who these people are or aren't. A lot of times it just means that they got notice that somebody died, and that's about it. So it's a jumping off point. It's not something you want to trust too much.
And then it also could be that if it was a homestead property, it's not even owned by the estate.
Correct.
Anymore. So that could actually be not only inaccurate, but wrong, completely wrong. So don't rely entirely on that, especially if you're dealing with issues of trusts and estates. I think is the point here.
And by the way, as agents, if you're the listing agent, you're dealing usually with the heirs, okay? Because the owner is dead and Ouija boards don't work. Yeah, so, you're dealing with these people. You can ask them, hey, is there a will? Have you started probate? Who's the attorney who's handling the probate? If you get an answer to that question, that's gold. You can just call that attorney up and say, hey, they want to sell the house. What do we need to do? Are they able to even sign a listing agreement with me? Now, I know how important it is to get everything signed yesterday, but sometimes you just can't because nobody has been yet named to be able to sign for something. And if you don't have the right person, by the way, on your listing agreement is worthless. So, you're better off waiting to get everything in order so that at least you're going to get paid.
We're going to move to homestead exemption now, Peter. Why does a husband whose name is not on the deed have to sign a contract or a listing agreement for the sale of his wife's homestead property?
Okay. Now we get into some nitty-gritty of homestead. Let's first start with, in Florida, there are 3 different types of recognized homestead. And by that, I mean, it has to do with 3 different things. The one that we're all familiar with is you get the homestead tax exemption. That's a great one. Okay, if you live there and you claim it as your homestead, you save money. You have to just file with the property appraiser's office. The second one is it protects you from creditors. As a general rule, creditors cannot get a lien against homestead property in the state of Florida. The exceptions are 1, mortgages. If you sign that lien and say, yes, here, you can have this lien, it's a good lien. Second exception, IRS, because the IRS always wins. And a third exception would be real property tax liens. If you don't pay your real property taxes, that's an exception. Another one is if you invite a contractor into your home and say, hey, I want you to put this addition on here, and then you don't pay them and they've done the work, they can lien your property for the work they've done. Outside of that, it is highly unlikely that somebody's going to get a lien against homestead property. So that's protection from creditors. The third one has to do with who you are allowed to leave your homestead property to when you die. If I own my homestead just in my name, and I'm married when I die, my wife has rights in that homestead. She has either a life estate, or she can elect to own half of it as a tenancy in common with my children. Okay, so, you know, it's a lot of these things going on. Now, just because you don't have a homestead tax exemption does not mean that it's not your homestead for the purposes of who gets to get it when you die, or for purposes of protection from creditors. I may have just decided I didn't want to file for my homestead exemption. Or it may just be that I bought the house this year and my exemption isn't even in place yet. Because your homestead tax exemption doesn't come in place until the January 1st, when you both own it and are residing there as your homestead. So just because I don't have the homestead tax exemption showing on the property appraiser does not mean it's not homestead. All right, and the wonderful thing about homestead in Florida is it's all a state of mind. If I intend to be living there as my primary residence, you know, it's not, well, do you spend at least 50% of the time there? Because what about people who have 3, 4, 5 different homes? They don't spend 50% of the time in any one of them. It's which one are they saying is their actual homestead? Where do they file, you know, where do they file their tax returns from? Where's their car registered? Where's their driver's license? Where are they registered to vote? These are the things that you look at to see if this is their homestead. So, having given you all of that, the reason why the wife has to sign on even the listing agreement, and there's case law where husband owned the property, it was homestead, wife never signed the listing agreement, they got to closing, wife never signed the contract, they got to closing and wife refused to sign the deed. There was nothing anybody could do about it, and there was nothing that the realtor could do to collect a commission because she never signed the listing agreement, okay? Because she has rights that are not extinguished merely by the execution and delivery of a deed, she's got to be on there. By the way, that's the reason why the spouse always has to sign on the mortgage. But she's not going to be on the note. Her credit doesn't matter. She doesn't count. It doesn't matter. In the state of Florida, she must sign on that mortgage so that her rights as a spouse can be foreclosed out if they don't make payments. Okay, now start asking questions. Yes.
You had mentioned earlier that you had a case where the will gave it to a friend and then they have 2 surviving children. How could that will give it to a friend if the children are home?
No, the will gave it to 2 children plus a friend.
Right, so plus a friend. How did that friend get it?
As long as you don't have a surviving spouse, so when you die, you're single, and you don't have any infant children, you are allowed to leave your home to anybody you want.
And infant being under 18?
Under 18, 18 or under, yes. All right, so you can leave it to anybody you want. If you don't have a will, it will go, you know, generally speaking, you don't have a spouse, it's going to go to your children. I know there's got to be a lot more questions than just that one.
Oh, I have a good one.
Yes.
What happens if you have CN property, commercial combined with a residential? Can you claim as a homestead?
Okay, you're going to have to define for me what you mean. The question was, what if you have commercial combined with homestead? You mean like you have a duplex, a 2-family home?
I mean, it could be one day out, but the property has proportional, like for, it has to be like more commercial, like 51% got to be commercial. And 49 can be a residential. It's called CN.
Okay, are you talking about where, like, we used to call them taxpayers, where you live upstairs and you have your store downstairs?
Okay, something like that.
Okay, your homestead is your homestead. So that is your homestead, that is protected. The commercial part, I don't know the answer to that one. Do you know if, I don't know if the commercial part is or is not protected as part of it. We do have to look at, is it, when it comes to homestead, by the way, not all homesteads are created equal. If you live within a municipality, okay, it's your home that sits on, was it less than 5 acres, I think, or is it 1 acre? I don't remember the acreage, but if you are not in a municipality, you're out in the farmlands, it's your home, your farm, plus your farm of up to 160 acres? Or is it 40?
It's 140.
It's either 40 or 160.
It's got a 1 in front of it.
Against
In
160.
that example, I think also it needs to be residential, so I don't think that would work.
No, actually, if you live
No, but
in the farmhouse,
Yeah,
I don't know if that does or doesn't work. So, but that's a very good question. And we'll try to get back to you on that.
Thank you.
Can we talk about how maybe ladybird deeds affect any of this?
That's a great question. Does everybody know what a ladybird deed is? Do you want to
Yes.
play, you want to play that one?
Oh,
I was just saying, do you want to, I don't want to just. Take
a
everything.
ladybird deed is also called an enhanced life estate deed. So essentially is when someone conveys property, usually to him and his wife or her and her husband, but can be individual also. But retains powers in the property. So typically in a life estate, when you retain a life estate and you convey the property to what's called remaindermen or remainder persons, to be politically correct, then you lose control of that property. Then you need everybody to sign a deed, a future mortgage, anything like that. You need the consent of everyone. With an enhanced life estate deed or a ladybird deed, you don't have to do that. You retain control of the real estate. You don't need the remainder parties' consent to deed or mortgage. So the question again was, how do we?
The ladybird deed is recorded against the title, right? In some way, shape.
Yes, if it's a homestead. Then
And usually the ladybird deed would go to kids.
right, usually you see it where it's a couple conveying to themselves with the remainder to the children.
Does that mean it's a life estate that can be sold?
Yes, they can still sell the
They
real
can,
estate.
actually, they can sell the whole thing, not
Mhm.
just the life estate.
So,
With a
for
ladybird.
example, if it is the kids have no control over that real estate until both parents have passed or they do something else to remove their interest. Okay,
But the general answer is yes, you can use a ladybird deed with homestead.
yes,
As long as you make sure that both husband and wife are signing on that deed. Mainly because with a ladybird deed, the remainder interest does not vest until the death of the parties.
Okay, Kara, I have another question for you. What if the owner of the property is a corporation or an LLC? Who is authorized to sign for a company?
okay, so you have an extra few steps involved here. You're still going to want to look at the most recent recorded deed. If you're lucky, that deed will not only give you the name of the company, the LLC or the corporation, but it will also tell you the state in which that entity has been formed. If it's a Florida entity, you just go to sunbiz.org and you do a search, and from there, you can scroll down the page a little bit and click on the most recent annual report that's been filed. Or if it's a very new entity, there won't be an annual report. And then in that case, you're going to look at the articles of incorporation or the articles of organization. But those documents will tell you who's named, if it's a corporation, who's named as president, vice president, secretary, treasurer. If it's an LLC, it's going to tell you who is named as a manager of the LLC, or if none, then a member of the LLC. If there's no manager of the LLC, then the members have authority to sign. If there is a manager, the law says that the manager has authority to sign in the absence of any information that you might have that's contrary to that.
Okay, question? No? Matt, okay, back to probate. What if the appointed personal representative dies or resign before a property is sold?
Well, so if they die, it would be the same as if they stopped serving, withdrew as the personal representative. Essentially now you're back to kind of square one. You've got nobody with authority to act. So you're gonna have somebody else come in and seek to be appointed, and the court's gonna have to make another appointment and issue new letters. And then once, the same thing again, once that person is appointed and the letters have been issued, they have their authority to go ahead and act on that estate.
So any listing agreements that might have been signed by the second person who died are now null and void?
Well, so no, I would say that, because they're acting on behalf of the estate. So I would draw an analogy, I'd say, to like a corporation or something. So, whatever the prior person did, they're bound by that still. So if you had a personal representative who signed a listing agreement, they're listing the property, that person dies, subsequent personal representative comes in, they're just representing the estate at that point. So they'd be bound by that. They can't come in and redo everything that was done.
Okay, Matt, this sort of follows up on that other question. What if the property has been distributed to beneficiaries that they cannot agree on selling the home? Can one beneficiary sign to sell the property?
So no, they can't. And I think Peter a little bit, talked about this. So no, you're gonna need them all. And I think this is, probably an area, and maybe people in here, experience this, but oftentimes somebody dies, they have multiple children. They've now gotten this house. They might not be able to agree on what to do with it. Maybe some of them one of them wants to live in it, a couple of them want to sell it, they can't agree on price, they can't agree on who to go with. Bad news is you're gonna need all of them. So you're gonna need all of them to sign to convey the property, and so you're gonna need them all in listing agreement. And if you can't, you're gonna have to do your best, I guess, to work with all of them and get them to agree. If they ultimately can't agree on what to do with the property, they have to do they can do as an option, what's called a partition action. So that would be a lawsuit in court where basically they can't agree on what to do with this property, and so the court is going to decide for them. And usually that's going to result in somebody being appointed to sell the house and to handle that whole process. So, what I would say to that is, at the outset, make sure that you have everybody that talking some of these resources that we're talking about to check. Make sure you know who owns this property, because you might get one of them calling you and saying, I just inherited this property and I want to sell it. And you get them, you're excited, you get them all signed up, and you find out there's 3 other ones. So make sure you have everybody, because what you don't want to have happen is you spend all that time, go through this process and realize, oh, there's some, distant brother or something who doesn't want to sell this property. And they're going to file a partition action possibly. And that's going to be the end of your deal. So make sure at the beginning, don't waste a lot of time. You have everybody on the same page.
If I may, by the way, there is a very new statute. It's only about 1.5 years old, called now heirs property partition. Unfortunately, I had the privilege of bringing one of those actions shortly after the papers were signed into law. And here's the problem you have with something like that. First, the judges have no clue how it works. Quite frankly, I had no clue how it worked. I spoke to the people who wrote the law, and they sent me a few of the forms, but it was really up in the air. And it's not easy, but basically with that though, what you can do is you can actually get an order where a realtor is named to sell the property. But actually the first step is in getting an appraisal done to say what's the property worth. And now the heirs have the right to buy each other out if they want. And if they don't, then it goes to the realtor and you can go ahead and sell it. On a regular partition action, unless everybody agrees to go to a broker and have it sold, basically the only thing they can do is have it sold at a public auction. The judge appoints someone to auction it off, which of course means no commission and usually less money for the people. It's not fun.
I've also seen it in the regular partition too, where the court can appoint a receiver and they can do a private
Yes.
sale as well.
Oh, yeah, if they agree
yeah.
to, they can do that, yes.
But yeah, on the new statute, that's right. It does add a new element to it where they can buy each other out. One thing that I've seen is where then a company comes in, buys one of the interests of the beneficiaries, with the hope of then, by that process, buying everybody else out as well. Without them having any real say. It's just something that's governed by statute.
Do you have a question?
I have an online question. Okay. If a seller owns a bunch of residential properties in the name of a revocable trust as a husband and wife, are there any legal restrictions on how many properties or transactions they may do a year selling the properties?
If the trust owns multiple properties, I'm not aware of any restrictions that say they can only sell 4 or 5 rather than all 10. But they can still only have one homestead. And nobody has more than one.
Cara, I actually read the statutes, even though I'm just an attorney, and I read that in Florida, there are circumstances where husband and wife can have separate homesteads within the same state based on jobs and proximity and so on. Never had the experience of it, but it was an interesting thing, It's not,
I've never seen it, but yes,
Yeah.
you're right.
And by the way, you know why that is, don't you? Because if you're a politician, you don't live with your spouse usually, and they want to be able to have their homestead wherever they are, so that's, my opinion only, not necessarily the opinion of Raism or anybody else, I'm sorry.
now,
It would only be half for tax purposes.
I'm sorry,
They would only get half of it. So be careful with that.
right,
They can only claim half of it.
that makes sense. But what about common law? So people like, I think it's called common law, where someone is not married, but they're domestic partners for 35 years. Is there any protection for them?
Well, Florida is not a common law state.
Gotcha.
Coincidentally, I'm originally from Rhode Island, where I practiced, and Rhode Island is still one of the few common law states. And I actually had some common law spouses that, but Rhode Island does not have homestead, so never had to worry about that.
Yeah, there's no protection for you at all if you're not married.
Wow, so if there's children together, then the children are the first line down. If let's just say husband and wife are not married, but they have 2 children, and the man owns the building that is homestead under his name, then the children are the heirs.
Well, if they are minor, yes, exactly. If they're minor, then they would get it, which is not a great thing because minors can't really do anything with real property. You have to get a guardian name. But if they're not minors, he could leave it to anybody he wants. So, yes, in the back.
So if there's a will with a common law situation, the husband dies and leaves it to the common law wife, that doesn't make a difference, they're asking.
Well, now if it's done in a will, then that would be the beneficiary under the will. But there's no common law where, like we've been together for 35 years, like in your example, and there's some kind of presumption at law that I'm the spouse. There's nothing like that in Florida. So pretty much, yeah, if you have somebody, you have children together, and you're not married, and if it is your intent to, let's say, leave them your house, you would need to do a will to effectuate that.
But what if they had minor kids? Then the minor kids still would get it.
Well,
Right?
the minor children would get it, and most likely the spouse would be named like a guardian ad litem for them or something, a guardian, but no, if you have adult children, you want to do a will. Basically, what I'm saying is if you are not married and you want to leave things to your spouse, you're going to want to do a will.
By the way, if you deal with much younger buyers and or sellers, Gen Zs and Gen Ys and Xs, I think, are the correct ones. I am finding more and more they call each other husband and wife. They have children together. They've been living together for umpteen years, but they're not married. And they don't understand really that they're not married. And they don't understand that there's a lot of stuff going on legally. You know, it's like, what do we need a piece of paper for? We're committed to each other. It's like, wonderful, that's great. And you don't need that piece of paper. Unless, of course, you want to go visit the baby's mama in the hospital when she's sick. Or you know, one of you dies or something happens, then it's really, really ugly. So I always recommend to them that they get a whole bunch of papers signed so that they have rights within each other. Otherwise, it can get very ugly very fast.
Okay, I have another question for you, Peter. What happens when a couple is getting a divorce and the husband is supposed to deed the homestead property to his wife?
Okay.
The wife, excuse me.
I don't know about you, but these things are the bane of my existence. Unfortunately, it seems to me the matrimonial bar doesn't understand that just because the husband deeded the property to the wife does not mean the husband is now off the mortgage. So that's the first problem you have with these things, because he's still responsible under the note. Additionally, sometimes the husband just doesn't sign the deed. Well, what happens? You actually have to look at the dissolution of marriage order and see what it says with respect to the property, and see what it says. If it says that the husband will sign a deed over, that's fine. But sometimes they actually do a smart thing and they make it self-effective, so that by the judge signing that order actually counts as the deed over to the wife. It's rare. Okay, don't get me wrong, it's very rare. Usually you're stuck with both of them still, because until the husband deeds it over, he still owns the property. Now, they don't own it as husband and wife anymore. It's still probably her homestead, could be his with the kids, goes both ways. And they now own it as tenants in common. I actually have a situation like that right now, where it was a do-it-yourself divorce, and that's really not a good thing. I don't do divorce law, so to me, I don't care. I don't make money off of this stuff. But they didn't even mention what happens to the real estate. They both had agreed. He can stay in the house because he wanted the house to be able to have their baby in that house and everything else. It was great as long as he paid for everything. And of course, COVID came along, he lost his job and he stopped paying the mortgage. But he got a deferment, and now that the deferment is over, it's in foreclosure. And she's saying to me, well, what happens with this? I said, well, first of all, you're named in the foreclosure, so say goodbye to your credit score. Second thing, you're still responsible on the mortgage, although the value had gone up significantly, so it was highly unlikely there's going to be a shortfall. But by the same token, she was entitled to half of the money. I said, well, you know, you really want to get him to sell it with you so that you can maximize your return. Otherwise, you're going to get very little when it's a foreclosure sale. So we actually had to start a partition action. And thank God, it took months, but the husband finally accepted the fact he's not keeping this house. And just a couple of days ago, I got the phone call. He's willing to settle. And yes, he'll go ahead and list it. Don't raise your hands. They already have somebody. But it's really, when these things happen, people don't understand why there are lawyers. There are lawyers because if you don't know what you're doing, you usually can get yourself into a lot more trouble than it's worth. So there you go.
Don't let anybody do their own deeds, please.
No.
For the small amount a lawyer will charge. Yes, Denise.
You may have already answered this, but Maria online is asking, just to confirm, I have a listing where the property owner is a trust. The trust is only in the name of the spouse. If the property is not homestead, then only the spouse on the trust has to sign the listing agreement and the closing document, not the husband, correct?
Okay, short answer. I should repeat that.
Do we need to-
Let me try to remember that whole thing. The question was if the property is owned by a trust and the trust is in the name of just one spouse, but it is not homestead, does the other spouse need to sign? So the short answer is no, but the long answer is please have the trust reviewed by an attorney because you don't know what's in that trust. The spouse might be a beneficiary and a beneficiary, there may be a clause in the trust that says the beneficiary needs to consent. And you don't know that until an attorney reviews. And also, even as Peter mentioned earlier, the property appraiser's website might not show it as homestead, but it still might be homestead. So you need to go a few more steps to investigate and have an attorney investigate to just make sure it really is not homestead.
Yeah, by the way, I just want to, I hate doing this, but I have to. As a lawyer, the words that we use are incredibly important. So let's start with a trust cannot own real property. A trust is not recognized in the state of Florida as an independent entity. That's why it has to be held by the named trustee as trustee of the trust. So when we talk about, and it's in the name of, or it's whatever, please say the trustee is the wife. The sole trustee is the wife. That's good. But when you say it's, in the name of the wife, that could mean that the wife's the beneficiary. But somebody else is the trustee. Okay, you've got to keep all the balls in the right order, in the right place. So recognize, there's a reason why we use these words, because they have real meaning. So with a trust, you have a trustee, you have beneficiaries, those are the people who benefit from the trust, who get the money that comes in, who get all of that, okay? And you also have someone called the grantor or settlor. The grantor or settlor is the person who made the trust. And then you have issues of who can change it, who can do things with it. So just recognize the names.
Sometimes you'll also see a husband and wife, they each have separate trusts. And they each may be trustees of their separate trusts. But again, beneficiaries, they might both be beneficiaries. Their kids might all be beneficiaries. There's a lot more that gets into it, especially when you're dealing with some high net individuals. And that's the reason that they have all these trusts.
And by the way, that's another thing that people used to do, and they probably still do, to try and get around homestead laws, which doesn't work. They'd say, okay, instead of owning it as husband and wife, I'm going to own it in my trust for my half. She's going to own it in her trust for her half. And now we don't have to worry about homestead because we're married, but it's not us, it's our trusts. That doesn't work. Okay, revocable trusts. So it's just one of those things where you really have to be careful and dive deep.
Kara, I'm not sure what, this is a good question right now, but what if, it says, what if the vesting deed shows a couple as husband and wife, but they are separated and not yet legally divorced? I don't know
Okay.
what a vesting deed is, I don't know.
So the vesting deed is whatever the most recent recorded deed is.
Okay.
And so the question was if there's a couple and on the deed, on the vesting deed, it says they are husband and wife. But they say, one of them says to you, oh, well, we're separated and my husband moved out 5 years ago.
Yeah.
I've had some that are even older than that.
And she doesn't know where he is.
And, but they never got, the divorce was never finalized. So in that case, it's hard for them to hear it, but they need to get their spouse. We gotta find that spouse. Because as long as they are still legally married, doesn't matter if they haven't seen each other for 5 years, they still both have rights in that homestead property. So, but if the divorce is final and there's a final order that's been recorded, then they own, as Peter said, they own now as tenants tenants in common. So they each own an equal percentage. Still need to find them though.
Find your husband. All right. Questions? Matt?
But he's gone back to Southeast Asia. He's in a village there. We don't know how to get in touch with him. we're laughing about this, but I mean, I'm sure you've seen it.
Well, not the Asian part, but.
Well, okay, I use that because I was trying not to be, I was trying to be politically correct. But no, I mean, it's, people don't understand it. Again, there's a reason why you need to do things properly, because otherwise it's a real problem.
Does that stay in limbo then, if they're in Southeast Asia?
It's not in limbo. She's there, she's living there, she got
can
it.
sell, she can get it
No, she can't sell,
relocated.
she can't
Can't
sell,
sell.
she can't sell, she can't finance, she can't borrow, she can rent it, but that's about it.
Did you have a question? Okay, Matt, we're back to you now. This has to do with incapacity. I don't think this is a repeat. What if the owner of property is incapacitated, and the family wants to sell a house to help pay for the person's care?
So basically, I mean, if somebody's incapacitated, they lack capacity to consent to contract or anything else. If they don't have the kind of estate planning in place that Peter was talking about, a durable power of attorney, then they can't assent to a contract, they can't deed a property, only at that point they would need a guardianship. So basically they would, petition to determine their incapacity, a court would determine whether or not they're incapacitated and appoint a guardian for them. And then at that point, it would be the guardian that would exercise authority to sell the house. And in the situation of a guardian, basically they would, similar to the estate, the court would appoint them. What's different about that is that you do need a court order actually to sell the property. And in fact, even in the state, which I don't think this was mentioned before, if there is no will, or if a will doesn't give the personal representative the authority to sell a property, they would also need a court order for that. So in a guardianship, they would get a guardian appointed and they would get authority to sell the property, and then you'd be ready to go.
Peter, I think we've got one final question from you.
Goody.
Does a wife need to sign the contract and listing agreement if the husband bought the homestead property in his own name before they were married?
And this happens too. Husband, single, buys a house, lives there, meets a nice girl, gets married, and they live there. Well, she still has rights now that she got married, even though he bought it beforehand, it was always his, it's now somewhat hers. So yes, she would have to sign everything, unless of course they got divorced first. But she's got rights, and you have to take that into account. Now I know whole thing has gotten into all kinds of crazy stuff, but believe it or not, you see these things. I've seen them, and I'm sure you have too. It's not always just, Mr. and Mrs. Smith selling their house. Where it's really easy. Okay, Mr. and Mrs. Smith is selling the house. Like, I know they own it. We looked it up. We're great. Oftentimes they do a lot of other little things that make it very difficult.
On more than one occasion, I've seen cases where a property was listed for sale in an estate situation well before there was anybody with authority to actually sell it, and they had to pull it off and go back and, do the proper channels. So just be aware of what, at least generally the kind of things that you need to look for. Who's going to have the authority, what they need to show their authority before actually, spending all the time going through the process.
Yeah, and when it comes to a company, a corporation, or an LLC, the more people that you find on Sunbiz that you get to sign off on it, the better off you are, even if they really didn't have to. As was noted, the president of a corporation can sign and bind the corporation. But I don't know how many times I've gone on Sunbiz and I see where people form the corporation and all it's got is directors. So who the heck is the president? You don't know. Or you have an LLC where they have one person as member, one person as manager, and a third person as authorized member. I don't know what that means. Have everybody and their mother sign. So at least that way, you've got a fighting chance at having got the right people.
I have numerous clients who are managers of LLCs or members of LLCs, and they keep calling themselves president. And I'm like, no, wait. So, and you'll see that on Sunbiz. You'll see a limited liability company and it will say president under the person's name. So who's that? There needs to be some extra steps in there to find out, is that person a manager, a member? We don't even want to get started talking about limited partnerships.
So, yeah,
Denise, do you have any more questions online? No? Does anyone have any questions? Because I'm out of their questions and I can't make them up.
So we really just talked about a lot of homestead. Now let's talk about investment property,
Okay.
you know, residential investment property. It sounds like not much of this applies. It sounds like who's the latest deed, the best of deed, that's who signs. Is that about
That's
right?
correct. Yes.
but usually an investment property is held either in a trust or in an LLC or in a corporation or in a limited partnership or a limited liability limited partnership. And then, like you said, you have to go to Sunbiz and
Right.
pray you've got everybody.
If it's formed in a different state, then you have to investigate further, because every state has different laws about who's authorized to sign. So it gets more and more complicated. And I know it sounds like a broken record, and it's not just because I'm a lawyer, but really, it's really helps to get a lawyer involved earlier rather than later, so you can figure all these things out.
And is the operating agreement between, let's just say, two partners, non-even partners, let's say one has major majority, one's just a little minor. Is the operating agreement, the document that dictates who has authority to sign?
Yes, if you're lucky enough that there is an operating agreement.
Right.
That's the bigger question there.
Occasionally, you'll get an LLC that's between two best buddies from college, and they say, we didn't do an operating agreement, what are you talking about?
And even if they're not best buddies.
And
Yeah.
if they cease to become best buddies.
Well, then there's something they didn't have.
And all we have done is file the articles
Right.
of organization or incorporation, and you'll go on there like send to see president, vice president, something like that.
Yeah,
But
Yeah.
I've got I hope a softball question for you.
okay,
What if you go online to look up the company and it says that they are no longer active because they didn't file their annual report?
yeah.
What happens then?
Well, if they're selling their sole asset, you know, say they formed an LLC just to own one piece of property as an investment. They're selling that investment property and they're going to not use that LLC anymore, then they can still convey. But if they're going to continue to own property, or if they own more than one property in that LLC, they have to bring that company back into compliance. They have to file however many annual reports they're behind on, pay all those fees.
Okay, Denise, I'm out of questions. And we're out of. I'm not sure about that.
Does the audience have questions?
Yeah, that's what I was wondering. Do you have any questions you would like to ask, Anna? Silly questions here.
No, okay, well, thank you very much to our panelists, Peter Pike, Kara Scott, and Matt Kelly for being here today. We have one more bit of unfinished business. I think Missy has a drawing. She likes to pull a card out of the
Yes, ma'am.
hat so that we can see.
In the drawing. 30 seconds, go.
And a big thank you to Deborah Patel for being our moderator today and doing such a great job of asking. And for the people who are online, in the chat, the contact information for our panelists were shared in the chat. So if you had any further questions after you log off and you wanted to ask, I'm sure that they'll have
Yes,
to
sir.
answer
Sorry
your
about that.
emails. So, okay, Missy, you have our final word.
and you can draw for me.
Okay.
I don't know if you have that.
Perfect. Oh, we have Deborah. Forcan is our winner today. Thank you again for everybody for being here today.